Welcome to this podcast on the English law of equity and trusts. We will cover the basic elements of the law as they relate to undergraduate law students and those taking the solicitor's qualifying examination, the SQE. This podcast was prepared by Dr. Yannis and is narrated by an AI voice. If you would like to know more about how this podcast was produced, get in touch with Dr. Yannis. Let's get started by presenting the basics of the law of trusts. Welcome to our discussion on the English law of equity and trusts. In this episode, we embark on a journey to understand the foundations of trusts and their place in the legal landscape. Trusts are an integral part of equity, and equity itself forms one of the two primary pillars of English law, the other being common law. Today we will explore equity, define trusts, and compare them to other related legal concepts, providing a strong foundation for understanding this fascinating subject. Equity. Equity represents a system of law designed to address shortcomings in common law. Historically, common law provided rigid and often inflexible solutions. Equity arose as a complementary system, offering remedies where common law was inadequate. Before the Judicature Act of 1873-75, courts of equity operated separately from courts of common law, each applying its own distinct rules. Today, these systems are fused, but equity remains a vital component of the legal framework, with its principles often applied by the Chancery Division of the High Court. Although primarily associated with trusts, equity also plays a crucial role in other areas of law such as contract and land law. For example, in land law, the doctrine of proprietary estoppel allows equity to provide remedies, even when formalities for land transactions are not met. In contract law, equitable remedies such as specific performance or injunctions go beyond the monetary damages typically awarded by common law. Conflicts between law and equity. Occasionally, common law and equity provide conflicting answers to legal disputes. Since as early as 1616, the principle established in the Earl of Oxford's case dictates that equity prevails in such situations. This principle remains enshrined in modern legislation, specifically Section 49 of the Senior Courts Act, 1981. However, this precedence does not render common law obsolete. Equity was designed to supplement common law, addressing its gaps and ensuring justice in unique circumstances. The two systems coexist, each essential to the broader legal framework. The fusion debate. The merger of the common law and equity courts raised questions about whether the merger was purely administrative or substantive. Some argue that the two systems retain their distinct rules despite sharing a single judicial structure. This view, famously articulated by Ashburner, likens equity and common law to two streams of jurisdiction that run parallel without mixing. Others question whether maintaining these distinctions is necessary or productive. Cases like Break-Fi, the Cheddington Court Estate illustrate that courts often exercise both jurisdictions without merging their substantive principles. The nature of equity. Equity is not synonymous with subjective fairness or justice. While it began as a flexible and discretionary system, it evolved into a structured body of rules governed by precedent. Critics who feared that equity might vary like the Chancellor's foot, a metaphor for inconsistency, were reassured by landmark judgments like G.V. Pritchard, which emphasized predictability and coherence in equitable decisions. However, equity's reliance on broad principles like unconscionability has sparked debate. While some argue that open-textured concepts allow for tailored solutions, others view them as unpredictable. Notable cases such as Bank of Credit and Commerce International v. Akindel and Pennington v. Wayne highlight this tension. As you delve deeper into this subject, consider how unconscionability shapes equitable outcomes and whether it enhances or undermines the legal system. Equitable maxims. Equity operates under guiding principles often expressed as maxims. These include phrases like, equity considers that done which ought to be done, and he who comes into equity must come with clean hands. These maxims encapsulate equity's ethos, but are not enforceable rules. They serve as interpretive tools that help courts navigate complex cases. For example, the maxim "equity will not assist a volunteer" reflects equity's reluctance to enforce gratuitous promises without consideration. What is a trust? A trust is a legal relationship in which one person, the trustee, holds property for the benefit of another, the beneficiary, or for a specific purpose. Trusts can involve personal property such as money or shares, or real property such as land. They are versatile tools used for various purposes, including family wealth management, pension schemes, and charitable activities. The key components of a trust include the settlor, who creates the trust, the trustee, who manages the property, and the beneficiary, who benefits from the trust. The property held in trust is known as the trust property or trust assets. Importantly, trusts can be either express, created intentionally by the settlor, or implied arising by operation of law. Why create a trust? Trusts serve multiple purposes. One common reason is to manage property for individuals unable to do so themselves, such as minors. Trusts also provide flexibility, allowing assets to be distributed over time or according to specific needs. For example, a trust might provide income to a spouse during their lifetime, with the remainder passing to children upon the spouse's death. Trusts also enable the pooling of resources, as seen in pension funds, which consolidate contributions for collective investment. Additionally, trusts can protect assets by ring-fencing them, shielding them from creditors in cases of bankruptcy. However, it's important to note that such protections must be established well before financial difficulties arise. The juridical effect of a trust. When a trust is created, it often results in a division of ownership. The trustee holds the legal title to the property, while the beneficiary holds the equitable interest. Some scholars argue that this division is metaphorical, with equitable rights being impressed onto the legal title rather than carved out of it. This nuanced debate underscores the complexity of trust law and its interplay between legal and equitable principles. Trusts arising by operation of law. Not all trusts are intentionally created. Constructive trusts, for instance, arise in response to unconscionable conduct, such as when a fiduciary profits from a breach of duty. Resulting trusts, on the other hand, emerge when property is transferred without clear intent, prompting equity to infer the appropriate outcome. These mechanisms ensure that trust principles extend beyond formal declarations, addressing situations where fairness demands equitable intervention. Comparing trusts to other legal concepts. Understanding trusts often involves comparing them to related legal relationships, such as agency, contract, and debt. While these relationships share similarities, they remain distinct in critical ways. In an agency relationship, an agent acts on behalf of a principal. Trustees, however, act in their own name for the benefit of others. Contracts, meanwhile, are fundamentally consensual agreements, whereas trusts can exist independently of mutual consent. Finally, while debts involve straightforward obligations to repay, trusts impose complex fiduciary duties on trustees, requiring them to act in the best interests of beneficiaries. Conclusion. Equity and trusts represent some of the most dynamic and impactful elements of the English legal system. They provide mechanisms for fairness, flexibility, and precision, addressing situations where rigid common law rules might fall short. By understanding these principles and their application, we gain insight into a system designed to balance the demands of justice with the realities of modern life. Thank you for joining me in this discussion. Stay tuned for our next episode, where we'll delve deeper into the specific types of trusts and their unique characteristics. Types of trusts. Welcome to our discussion on the different types of trusts. This topic builds on our previous exploration of trusts by examining their classifications and purposes. Understanding the terminology and distinctions between these types is essential for navigating the complex world of trust law. Today we'll explore express trusts, discretionary and fixed trusts, bare trusts, trusts arising by operation of law, testamentary and inter vivos trusts, and purpose trusts. Express trusts. The express trust is the most common type of trust. It is deliberately created by a settlor, the person who establishes the trust. The settlor may either declare that they will hold the property on trust for beneficiaries, becoming the trustee, or transfer the property to another person to hold as trustee. This declaration of intent is known as a declaration of trust. Sometimes, legal formalities such as a written instrument are required, depending on the nature of the property involved. For a trust to be valid, certain conditions must be met, much like the formation of a contract. The settlor must demonstrate a clear intention to create a trust, not merely express a hope or desire. This intention ensures that the trustee is bound by a duty to act according to the trust's terms. The principle of freedom of trust allows settlors to divide entitlements under the trust as they choose, within the bounds of the law. Discretionary and fixed trusts. Trusts can be categorized as either fixed or discretionary based on the obligations placed on trustees regarding the distribution of property. In a fixed trust, the distribution is predetermined by the trust instrument, leaving no discretion to the trustees. For example, a trust might specify that income from an asset be paid equally to all beneficiaries. In contrast, discretionary trusts grant trustees the power to decide how to distribute the property among beneficiaries. This flexibility allows trustees to respond to beneficiaries' varying circumstances over time. For instance, a settlor may create a trust for their children, allowing the trustees to determine how much each child receives based on their needs. A trust can also include both fixed and discretionary elements. For example, the income from shares might be distributed at the trustee's discretion, while the capital of those shares is divided equally among the beneficiaries when a specific condition is met. Bare trusts. A bare trust is a minimal form of trust where the trustee holds property to the order of the beneficiary. In this arrangement, the trustee simply acts as a nominee, following the beneficiary's instructions regarding the property. Bare trusts are often used in situations where the trustee's role is purely administrative, such as when shares are held on behalf of someone else. Trusts arising by operation of law. Not all trusts are intentionally created. Some arise by operation of law, either through statutory provisions or judicial intervention. T. Statutory trusts. 33 trusts are imposed by legislation to address specific issues. For instance, in English land law, co-owners of land hold the title on a statutory trust for themselves, as provided by the Law of Property Act 1925. While statutory trusts are beyond the scope of this discussion, they demonstrate how the law can use trusts to achieve policy objectives. Constructive trusts. A constructive trust arises when the law imposes a trust to address unjust enrichment or breaches of fiduciary duty. For example, in FHR European Ventures LLP v. Cedar Capital Partners LLC, a trust was imposed to recover secret permissions obtained in breach of fiduciary duty. Constructive trusts can also arise in cases of mistaken payments or when property is transferred under an incomplete contract. These trusts can be classified as either institutional or remedial. Institutional constructive trusts arise automatically based on established legal rules, while remedial constructive trusts depend on a court's discretion. English courts have generally been reluctant to recognize remedial constructive trusts, favoring the certainty of institutional trusts. Resulting trusts. Resulting trusts occur when property jumps back to the settlor or their estate due to a lack of clear intent or the failure of an express trust. They are divided into two categories: presumed resulting trusts, where property is transferred without consideration, and automatic resulting trusts, which arise when a trust fails partially or entirely. Now, implied trusts. The term implied trust is ambiguous and has largely fallen out of use. Depending on context, it can refer to either constructive trusts or express trusts inferred from the facts. Modern legal discourse avoids this term to reduce confusion. Whilst testamentary and inter vivos trusts. Trusts can also be classified based on when they take effect. A testamentary trust is created through a will and comes into operation after the settler's death. Typically, the executors of the will act as the initial trustees. By contrast, an inter vivos trust is established during the settler's lifetime and is a common form of express trust. Purpose trusts. Unlike most trusts, which benefit individuals or groups, purpose trusts exist to achieve a specific objective. However, non-charitable purpose trusts are generally invalid because they lack identifiable beneficiaries who can enforce the trust. Exceptions exist for certain testamentary trusts, but these are rare. Charitable purpose trusts, on the other hand, are valid and enforceable. They are regulated by the Charity Commission and the Attorney General on behalf of the Crown. These trusts play a significant role in advancing public benefits such as education, poverty relief, and healthcare. Conclusion. Understanding the different types of trusts provides insight into the flexibility and utility of trust law. From express trusts tailored to specific family needs to constructive trusts that address breaches of duty, each type serves a unique function within the legal system. By recognizing these distinctions, we can appreciate the nuanced ways in which trusts are used to manage and protect assets while ensuring justice and fairness. Thank you for joining me on this exploration of trust types. In our next discussion, we will delve deeper into the mechanisms that govern trust creation and enforcement. Stay tuned. C. Creating a Trust, the Three Certainties. Welcome to another episode in our series on trusts. Today we're tackling an essential concept, the three certainties required to create a valid trust. To form a trust, a settler must demonstrate an intention to create it, specify the property that will be held on trust, and identify the beneficiaries who will benefit from it. These are known as certainty of intention, certainty of subject matter, and certainty of objects. Understanding these certainties is fundamental to trust law and ensures that the trust functions as intended. Certainty of intention. The first certainty focuses on the settler's intent to create a trust. Courts look for clear evidence that the settler intended to impose legally binding obligations on the trustee to hold property for the beneficiaries. This evidence can come from spoken or written words, or in some cases, from conduct. To illustrate, consider Re van der Velde's trust, numbered to D2, where the court emphasized that mere unexpressed intentions are insufficient. Similarly, in Paul v. Constance, a man's repeated statement that money in a bank account was as much yours as mine was held to demonstrate sufficient intention to create a trust. However, the courts apply an objective test, focusing on how a reasonable person would interpret the words or actions in question. Uncertainty often arises in cases involving gratuitous transfers of property. For instance, in Re Adams and Kensington Vestry, a testator's statement that he left his estate to his wife in full confidence that she would do what was right for their children was deemed insufficient to create a trust. The court held that these words reflected a moral obligation, not a legal one. Another challenge occurs when the settler's intention is ambiguous, as in Jones v. Locke. Here, a father handed a check to his infant son saying, "I give this to baby for himself." The court found no intention to create a trust, emphasizing the need for clear and binding expressions of intent. Certainty of subject matter. The second certainty requires the trust property to be clearly identified. Without this, the trust cannot function. Trust property can be almost anything: land, money, shares, or even intangible rights, but it must be defined with precision. Difficulties arise when the trust property is part of a larger mass. For example, in Re London Wine Co., a trust over bottles of wine failed because the bottles were not segregated, making it impossible to identify which were held on trust. In contrast, the decision in Hunter v. Moss upheld a trust over a proportion of shares, even though specific shares were not identified. The court reasoned that shares of the same class are fungible and do not require segregation. Conceptual uncertainty can also invalidate a trust. For example, in Palmer v. Simmons, a trust for the bulk of the settler's estate failed because the term bulk was too vague. Conversely, in Ray Gollet's will trusts, a direction to provide a reasonable income was upheld, as the court could determine what was reasonable. It is worth noting that future property or property the settler does not yet own cannot be the subject of a trust. For instance, a settler cannot create a trust over an inheritance they expect to receive. This principle underscores the requirement that trust property must exist and be identifiable at the time the trust is created. Certainty of objects. The final certainty ensures that the beneficiaries of the trust are sufficiently identified. This is crucial because trustees must know whom they owe duties to and who can enforce the trust. For fixed trusts, the complete list test applies, meaning all beneficiaries must be identifiable. For example, in IRC v. Broadway Cottages Trust, a trust failed because the beneficiaries could not be completely identified. Discretionary trusts, however, use a less stringent test. In McPhail v. Dalton, the court established the any given postulant test, which requires trustees to determine whether any given person is or is not a member of the class of beneficiaries. Conceptual clarity is essential here, as vague terms like friends or tool people may render the trust invalid. However, evidential uncertainty, where sufficient evidence is lacking to prove a person's inclusion, does not necessarily invalidate a discretionary trust. In some cases, the courts allow third parties to resolve uncertainties. For example, in Retux settlement trusts, the court upheld a provision allowing a third party to determine whether a beneficiary met certain criteria. However, this approach remains contentious and is not universally accepted. Administrative workability and capriciousness. Even if the three certainties are satisfied, a trust may still fail if it is administratively unworkable. This issue arises when the class of beneficiaries is so large or ill-defined that the trustees cannot perform their duties effectively. For example, a trust for the inhabitants of London might be deemed unworkable due to its vast scope. Additionally, capriciousness, where the trust's terms appear arbitrary or lack a rational basis, can also invalidate a trust, as noted in Yannis's settlement trusts. Conclusion. The three certainties, intention, subject matter, and objects, form the foundation of trust law. They ensure that trusts are created with clarity and precision, protecting both trustees and beneficiaries. By understanding these principles, we gain insight into the mechanisms that make trusts a reliable and effective tool in equity. Thank you for joining me in this discussion. Stay tuned for our next episode, where we'll explore the beneficiary principle and non-charitable purpose trusts. The beneficiary principle and non-charitable purpose trusts. Welcome to our exploration of the beneficiary principle and non-charitable purpose trusts, a complex yet fascinating aspect of trust law. Today we'll delve into the general prohibition on private purpose trusts, the limited exceptions, and the theoretical underpinnings that shape this area of law. Introduction. The beneficiary principle lies at the heart of trust law, requiring that every trust, except for charitable trusts, has identifiable human beneficiaries. Without such beneficiaries, non-charitable purpose trusts are typically void. The rationale for this principle is rooted in enforcement. A trust without beneficiaries lacks individuals who can hold trustees accountable. While charitable trusts rely on oversight by the Charity Commission or the Attorney General, non-charitable purpose trusts face unique challenges due to their private nature. Objections to non-charitable purpose trusts. Several objections underpin the prohibition against non-charitable purpose trusts. Uncertainty of objects. Non-charitable purpose trusts often fail due to the absence of identifiable beneficiaries. For instance, in Re Asta's settlement trusts, 1952, a trust for vague purposes like maintaining good understanding between nations was deemed invalid. Similarly, Morris v. Bishop of Durham, 1805, reinforced the necessity of ascertainable beneficiaries to enforce trust obligations. Excessive duration. The rule against perpetuities prevents trusts from lasting indefinitely. Trusts that might exceed the legally allowed period are void, as seen in Macaulay v. O'Donnell, 1943. However, exceptions exist for specific cases, such as Musset v. Bingle, 1876, where a trust to erect a monument was upheld despite potential perpetuity concerns. Lack of beneficiaries. The absence of beneficiaries undermines a trust's enforceability. In Re Endicott, 1960, the court emphasized that a valid trust requires beneficiaries with equitable interests. However, in Re Denley's Trust Deed, 1969, Goff J. suggested that individuals deriving factual benefits from a trust could enforce it, creating a notable divergence in judicial interpretation. Excessive testamentary delegation. Purpose trusts risk delegating testamentary power excessively, leaving trustees with unchecked discretion. However, this objection is often secondary to the fundamental issues of uncertainty and lack of beneficiaries. The beneficiary principle. At its core, the beneficiary principle asserts that trusts must either benefit identifiable individuals or qualify as charitable. This principle ensures that trusts remain subject to legal control, as articulated in Maurice v. Bishop of Durham, 1805. Scholars debate whether the principle represents a rights or enforcer approach. The rights perspective holds that beneficiaries must have equitable rights to enforce the trust, while the enforcer perspective suggests that a designated enforcer could suffice, even in the absence of equitable interests. Some jurisdictions, like the Cayman Islands and Guernsey, have experimented with public enforcers for non-charitable purpose trusts. However, these approaches remained contentious, as they challenge traditional notions of private rights and obligations. Valid non-charitable purpose trusts. Despite the general prohibition, English law recognizes limited exceptions, often referred to as anomalous trusts. These include tombs and monuments. Reasonable provisions for maintaining graves or monuments, such as in Re Dean, 1889, are upheld. Care for specific animals. Trusts for the upkeep of particular animals, also seen in Re Dean, are permissible within perpetuity limits. Paying of masses. Trusts for religious masses, provided they are not exclusively charitable, have been validated, as in Bourne v. Keane, 1919. Courts manage these trusts of imperfect obligation through mechanisms like the Pettingall Order, Pettingall R.C.'s Pettingall, 1842, allowing residual beneficiaries to enforce the trust if trustees fail to act. Re Denley's Trust Deed and its implications. In Re Denley's Trust Deed, 1969, Goff J. upheld a trust for land to be used as a recreation ground for employees, arguing that the employees' direct benefits gave them standing to enforce it. While some commentators view this as a discretionary trust or a trust for persons with a purpose attached, others argue it challenges the beneficiary principle itself. Subsequent cases like Re-Lipinski's Will Trusts, 1976, have sought to reconcile re-Denley within existing legal frameworks, emphasizing the importance of certainty in beneficiary identification. Trusts for persons limited by a purpose. Some trusts, like those in Rees Sanderson's Trust, 1857, specify purposes to define a beneficiary's interest. These are not true purpose trusts, as the beneficiaries retain enforceable rights. For example, trusts for a child's education or maintenance allocate funds based on the cost of achieving the stated purpose. Any surplus typically reverts to the settler's estate or passes under a gift-over clause. Conclusion. The beneficiary principle remains a cornerstone of English trust law, ensuring enforceability and legal accountability. While non-charitable purpose trusts are generally void, exceptions like Re-Denley and anomalous trusts illustrate the law's capacity for flexibility. However, these exceptions are narrowly defined, reflecting a cautious approach to expanding the principle. As we conclude this episode, consider the creation of trusts and transfer of interest under trusts. Formalities, creation of trusts and transfer of interest under trusts. Welcome to today's discussion on the formalities surrounding the creation of trusts and the transfer of interests under trusts. These rules ensure clarity, prevent fraud, and provide certainty in trust law. We'll explore declarations of trust, testamentary trusts, and the formalities for transferring equitable interests. Declarations of trusts of land. When it comes to trusts involving land, written evidence plays a crucial role. Under Section 53, 1b of the Law of Property Act, LPA, 1925, declarations of trust concerning land must be manifested and proved by signed writing. This rule, which originated with the Statute of Frauds, 1677, is not a condition for creating a trust but an evidential requirement. For example, an oral declaration of a land trust is valid, but without written evidence, it cannot be enforced in court. Gissing v. Gissing, in 1970. However, there are exceptions to this rule. In Rochefoucauld c. Busted, 1897, the court allowed oral evidence to prove a trust, preventing the statute from being used to perpetrate fraud. This case demonstrates equity's principle that it will not allow statutes to become instruments of fraud. Despite its logic, this reasoning has been debated due to its circularity, as it presupposes the existence of a trust. Testamentary trusts. A testamentary trust is one created through a will and takes effect upon the testator's death. Under Section 9 of the Wills Act, 1837, a valid will must be in writing, signed by the testator, in the presence of two witnesses who also sign. These formalities aim to ensure the testator's intentions are clearly documented and prevent disputes after their death. Despite these requirements, courts have upheld secret trusts that do not comply with the Wills Act. Secret trusts operate outside the formal framework of wills, relying on the testator's communication of their wishes to trustees. This apparent contradiction raises questions about the relationship between statutory requirements and equitable principles. Transfer of interests under trusts. Section 53, 1c of the LPA 1925 governs the disposition of equitable interests under trusts. It requires dispositions to be in writing, signed by the person disposing of the interest or their authorized agent. This rule ensures that transactions involving equitable interests are clear and reduces the risk of fraud. The interpretation of disposition is broad, as established in Gray v. IRC, 1959. In this case, an oral direction by a beneficiary to trustees to hold their equitable interest for another party was held invalid until documented in writing. Other scenarios caught by this rule include assignments of equitable interests, self-declarations of subtrusts, Nelson v. Greening Sykes, 2007, and disclaimers of interests, Re Paradise Motors Limited, 1968. Exceptions to the writing requirement exist, particularly where there is no risk of fraud. For example, in Vandervelde v. IRC, 1966, the House of Lords held that Section 53(1)(c) did not apply where the equitable interest ceased to exist, as there was no longer a trust to protect. The rationale for formalities. The formalities outlined in Sections 53(1), (b) and (c) serve to prevent fraud and provide certainty in trust transactions. However, these provisions can also create challenges. For instance, rigid adherence to formalities and invalidate genuine trusts or dispositions, while exceptions may blur the lines of consistency. Courts must balance the need for certainty with equitable principles, as seen in cases like Rochefoucauld and Gray. Conclusion. Formalities in trust law ensure that trusts are created and administered with clarity and integrity. While rules like those in the LPA 1925 and the Wills Act 1837 aim to prevent fraud, equity's role in addressing exceptional circumstances highlights the law's adaptability. As we continue to examine trust law, we'll see how these principles interact with evolving societal and legal contexts. Thank you for joining me in this discussion. Stay tuned for our next episode, where we'll explore the Constitution of Trusts. The Constitution of Trusts. Welcome to today's exploration of the Constitution of Trusts, an essential aspect of trust law. This topic addresses how a trust becomes fully constituted, the implications of defective constitution, and the rare situations where equity might step in to address imperfections. By the end of this discussion, we'll have a clearer understanding of how property is transferred to trustees and the principles guiding these processes. What does it mean to constitute a trust? The constitution of a trust involves transferring property to the intended trustees, ensuring that the trust is fully operational and enforceable. Once constituted, trustees hold legal title to the trust property, and beneficiaries can enforce the trust's terms. Importantly, a completely constituted trust cannot be revoked by the settlor, even if the beneficiaries gave no value in exchange. Self-declared trusts, where the settlor is also the trustee, do not require a transfer of property. For other trusts, the process of transferring property varies depending on the type of asset involved. Land. Transfer requires registration with the Land Registry under the Land Registration Act 2002. Chattels. Property is transferred through physical delivery or execution of a deed. Shares. Private company shares require registration in the company's share register. Choses in action. These, such as debts, require written assignment under Section 136 of the Law of Property Act 1925. When these formalities are followed, the trust is considered fully constituted, allowing beneficiaries to enforce it. The defective constitution. If a trust is not properly constituted, equity generally adheres to the principle that equity will not assist a volunteer. This maxim, established in Milroy v. Lord, 1862, means that courts will not intervene to perfect an imperfect trust or gift. An imperfect attempt to transfer property to a trustee will not be reinterpreted as a self-declaration of trust, as confirmed in Richards v. Delridge, 1874. However, equity recognizes exceptions where the general rule is too rigid. Courts have identified specific scenarios in which they will step in. Detrimental reliance. If a donee relies on an imperfect gift to their detriment, courts may enforce it under the doctrine of proprietary estoppel. For example, in Dilwyn v. Llewellyn, 1862, a son who relied on a promise of land and built a house on it was awarded the land. The rule in Re Rose, 1952. This rule applies when a donor has done everything in their power to transfer property but external formalities remain incomplete. In such cases, the donor is considered a constructive trustee until the transfer is finalized. The rule in Strong v. Bird, 1874. If a donor intends to make a gift and later appoints the intended donee as their executor, the gift is perfected upon the donor's death. This rule has been extended to various forms of property, as seen in Re Stewart, 1908. The rule in Re Raleigh's Will, Trusts, 1964. Even where there is no continuing intention to give, the receipt of property by an executor may constitute a promised trust. This case blurs the lines of intention and constitution. Donatio mortis causa. A gift made in contemplation of death, conditional upon the donor's death, may be upheld without satisfying typical formalities. In Sen v. Headley, 1991, the delivery of keys to a deed box containing the title to property was sufficient to validate the gift. Unconscionability. In Pennington v. Wayne, 2002, the Court of Appeal held that equity could perfect an imperfect gift if it would be unconscionable for the donor to retract their intention. This controversial decision departs significantly from traditional principles. Examining key cases. Several landmark cases illustrate these principles. Milroy v. Lord, 1862, established the general rule that equity will not perfect imperfect gifts or trusts. V. Rose, 1952, demonstrated the importance of a donor doing everything within their power to transfer property. Pennington v. Wayne, 2002, introduced the concept of unconscionability, expanding equity's role in imperfect gifts. T. Choithram v. Pagarani, 2001, highlighted how a settler's words and actions could be interpreted generously to find a trust where formalities were incomplete. The role of equity. Equity's interventions in defective constitution reflect its focus on fairness and justice. However, these exceptions challenge the traditional maxim that equity will not assist volunteers. Critics argue that concepts like unconscionability lack clarity and predictability, potentially undermining the consistency of trust law. Conclusion. The constitution of trusts involves precise formalities to ensure clarity and enforceability. While the general rule prohibits courts from assisting with imperfect trusts or gifts, equity's exceptions demonstrate its capacity to adapt to individual circumstances. By balancing formal requirements with equitable principles, courts strive to uphold justice without eroding the foundational rules of trust law. 8. Thank you for joining me in this discussion. Stay tuned for our next episode, where we'll delve into promises to create trusts. Promises to create trusts. Welcome to today's discussion, where we will explore the nuances of promises to create trusts. This topic examines when promises become enforceable, who can enforce them, and the legal mechanisms involved. By the end, we'll understand the principles governing promises in deeds, promises given for consideration, and those arising from detrimental reliance. Rapid introduction. Promises to create trusts often begin as mere intentions, but not all are enforceable in English law. Equity and common law both maintain that a bare promise is insufficient. However, there are 3 exceptions where such promises can gain legal recognition. Promises made in deeds, also called covenants. Promises supported by consideration. Promises detrimentally relied upon, as seen in cases of proprietary estoppel. Each of these exceptions has distinct rules and implications, which we will now explore in detail. Promises in deeds. A promise contained in a deed, known as a covenant, can be enforced by parties to the deed. For instance, in Cannon v. Hartley, 1949, a father's promise in a deed to pay his daughter any inheritance exceeding £1,000 was enforceable at law. Importantly, equity does not enforce such promises unless supported by consideration or enforcement by beneficiaries. Watch. Beneficiaries who are not party to a deed face significant challenges. However, 3 scenarios might allow them to enforce the promise. Statutory inclusion. The contracts. Rights of third parties. Act 1999 potentially enables third parties to enforce covenants, provided they satisfy statutory criteria. However, it is uncertain whether the Act applies to voluntary covenants. Marriage consideration. In historical marriage settlements, children or grandchildren were considered within the marriage consideration and could enforce promises. Equity treated these promises as constructive trusts, but this practice is now rare. Trust of the right to sue. Trustees who are parties to a covenant can sue for breach. If the trust of the covenant argument holds, trustees must exercise their rights on behalf of the beneficiaries. However, this approach is controversial and limited to present, not future, property. Cook's Settlement Trusts, 1965. Enforcement by trustees. Trustees, being parties to the covenant, can sue at law. However, equity sometimes prevents them from doing so, as seen in Price, 1917. Courts reasoned that enforcing a covenant on behalf of a volunteer would indirectly achieve what equity denies outright. This principle was upheld in subsequent cases, such as K. 1939 and Cook's Settlement Trusts, 1965. Promises for consideration. Promises supported by consideration are treated as contracts. If a settler promises to establish a trust in exchange for consideration, the promise becomes enforceable at law or equity. However, the issue of privity arises if the intended beneficiary is not a party to the agreement. While the Contracts, Rights of Third Parties Act 1999 may provide relief, it remains unclear whether voluntary covenants qualify as contracts under the Act. Promises and detrimental reliance. Equity may enforce a promise where the promisee has relied on it to their detriment, even without consideration. This principle, rooted in proprietary estoppel, requires the promisee to demonstrate reasonable reliance and resulting detriment. In Basham, 1986, a plaintiff who cared for her stepfather in reliance on his promise to leave her property successfully claimed the estate. Detrimental reliance does not guarantee the fulfillment of the promise. Courts may choose alternative remedies based on fairness, as in Jennings v. Rice, 2002, and Guest v. Guest, 2022. Critique of judicial reasoning. Cases like Price have sparked academic debate. Critics argue that trustees' inability to enforce covenants undermines beneficiaries' rights. Others suggest that denying enforcement aligns with equity's refusal to assist volunteers. This tension illustrates the balance courts must strike between enforcing promises and maintaining equitable principles. Conclusion. Promises to create trusts highlight the interplay between common law and equity. While rigid rules often limit enforcement, exceptions for deeds, consideration, and detrimental reliance demonstrate equity's adaptability. Understanding these principles is crucial in navigating the complexities of trust law. Thank you for joining me. In our next episode, we'll explore charitable purpose trusts. Charitable purpose trusts. Welcome to today's discussion, where we'll explore the fascinating world of charitable purpose trusts. These unique trusts form a critical part of equity and trust law, offering special advantages while addressing complex legal questions about their validity, public benefit, and administration. Today we'll cover the meaning of charitable purposes, the public benefit requirement, and the challenges posed by non-charitable elements and the Side-Brez doctrine. Introduction. Charitable purpose trusts are distinct because they exist to promote specific purposes rather than benefit individuals. To be valid, these trusts must meet several legal criteria, the most critical being that their purpose is charitable. Charitable status grants numerous benefits, including exemptions from the beneficiary principle the perpetuity rule, and certain tax obligations. The primary governing statutes are the Charities Act 2011 and more recently the Charities Act 2022. At their core, charitable trusts must exclusively serve charitable purposes. Mixed purposes where non-charitable elements are included can invalidate the trust. Courts have been tasked with interpreting what constitutes a charitable purpose and addressing the public benefit requirement. These tasks often raise difficult questions, particularly in borderline cases. The meaning of charitable purposes. The definition of charity has evolved over centuries. Historically, the preamble to the Statute of Charitable Uses 1601 provided the foundation. In Income Tax Commissioners v. Pemsel, 1891, Lord Macnaghten categorized charitable purposes into 4 heads: the relief of poverty, the advancement of education, the advancement of religion, and other purposes beneficial to the community. The Charities Act 2011 expanded these categories to include 13 specific heads of charity, such as the advancement of health, amateur sport, and environmental protection. Courts rely on this statutory framework while drawing on case law to determine whether a purpose is charitable. For example, trusts for the relief of poverty do not require recipients to be destitute, but must address genuine financial hardship. Brick, 1951. Meanwhile, trusts for education or religion are interpreted broadly, encompassing a variety of activities, such as artistic endeavors or promoting ethical beliefs. However, charitable purposes must provide tangible benefits. The Charities Act 2011, Section 4, explicitly states that no presumption of benefit exists. Every trust must positively demonstrate its public benefit. In National Anti-Vivisection Society, VIRC, 1947, the court weighed the benefits of suppressing vivisection against its detriments to medical research, emphasizing the importance of balancing competing considerations. The public benefit requirement. Public benefit is a cornerstone of charitable trusts. To qualify, a trust must benefit the public or a sufficiently broad section of it. This requirement prevents private arrangements from masquerading as charities. Exceptions exist, particularly for trusts relieving poverty, where the personal nexus rule does not apply. In Dingle v. Turner, 1972, a trust benefiting employees of a company was upheld because it relieved poverty, even though it was limited to a specific group. By contrast, in Oppenheim v. Tobacco Securities Trust Co-Limited, 1951, a trust for the education of employees' children failed due to the personal nexus test. The public benefit requirement also demands that charitable trusts not exclude the poor. Fee-charging schools and hospitals, for instance, must ensure accessibility for those unable to pay. The Independent Schools Council v. Charity Commission, 2011, clarified that mechanisms such as scholarships can satisfy this requirement, contaminating non-charitable elements. Charitable trusts must be exclusively charitable. Non-charitable elements, such as political purposes, can contaminate and invalidate the trust. In McGovern v. AG, 1982, a trust supporting Amnesty International's campaigns was deemed non-charitable because it sought changes in the law. While promoting human rights is charitable under the Charities Act 2011, the line between permissible advocacy and political campaigning remains blurred. Courts may interpret ambiguous trust terms generously to preserve charitable status. In Guild v. IRC, 1992, seemingly non-charitable elements were construed as ancillary, ensuring the trust's validity. In some cases, non-charitable and charitable purposes can be severed, allowing the charitable part to continue. Salisbury v. Denton, 1857. The Cypress Doctrine. The Cypress Doctrine addresses situations where a charitable trust's purpose becomes impossible or impractical to achieve. Derived from the French term as near as possible, the doctrine allows courts to redirect trust funds to similar purposes, preserving the settler's charitable intent. Initial failure occurs when a charitable purpose cannot take effect from the outset. In such cases, the court must determine whether the settler intended a general charitable purpose. If so, see Prep and apply. Fingers WT, 1972. Subsequent failure, where a purpose becomes impractical after taking effect, automatically invokes C. Pres. The Charities Act 2011 Section 62 provides statutory guidance for applying the doctrine, granting courts flexibility to adapt to changing circumstances. Conclusion. Charitable purpose trusts exemplify equity's adaptability and its commitment to public benefit. They enjoy unique privileges but face stringent requirements to ensure their integrity. By balancing statutory provisions and judicial interpretation, courts continue to refine this vital area of trust law. Thank you for joining me in this discussion. Stay tuned for our next episode, where we'll delve into unincorporated associations. Unincorporated associations, their legal complexities and trusts. Welcome to our latest discussion in the Equity and Trusts series. Today we'll unravel the intricacies of unincorporated associations, groups that lack legal personality, yet manage to hold property and organize activities. These associations, from student societies to local sports clubs, create fascinating challenges for the law, particularly regarding how they hold and distribute property. Introduction. Unincorporated associations are groups formed by individuals to achieve a shared purpose. Unlike incorporated bodies such as companies, they lack legal personality, meaning they cannot hold property in their own name. Yet donations and transfers to these associations continue to occur, requiring the courts to interpret and enforce these arrangements. Typically, the challenges associated with unincorporated associations arise in two key areas: the construction of gifts and transfers made to the association, the distribution of property when the association dissolves. Through judicial creativity and legal doctrines, courts have sought to address these issues, sometimes with surprising results. Transfers to unincorporated associations. Transfers of property to an unincorporated association can take several forms, each raising unique questions. Let's explore the primary approaches the courts have taken. A transfer to members. The simplest interpretation of a transfer to an unincorporated association is that it is a transfer to the members as co-owners. Each member receives an equal share of the property, which they can use as they wish. However, this approach often undermines the donor's intentions. For example, a donation to a student law society intended to fund events might instead be divided among its members for personal use. A purpose trust. Another approach interprets the transfer as creating a trust for the purposes of the association. In this case, the property cannot be distributed among members, but must be used exclusively for the association's stated purposes. Unfortunately, this interpretation often fails because most purpose trusts are non-charitable and thus invalid under English law. Leahy v. AG for New South Wales, 1959. Some exceptions, such as those established in Re Denley's Trust Deed, 1969, apply when a trust benefits identifiable individuals. The contract holding theory. A more modern approach. The contract holding theory resolves many of these issues. It recognizes that members of unincorporated associations are bound by mutual agreements or rules. Transfers to the association are treated as contributions to a collective fund held by officers or trustees in accordance with the association's rules. This approach avoids the pitfalls of purpose trusts, as the obligations are contractual rather than fiduciary. Rare Resch's W.T. 1972. Lipinski's W.T. 1976. Under the contract holding theory, two variants exist. Bare trust contractual mandate solution. Property is held on bare trust by officers for all members equally, but the association's rules dictate its use. This allows members to achieve the association's purposes without breaching trust law. Purely contractual approach. Property is owned jointly by members as co-owners, with the association's rules governing its use. However, this is less practical for large associations. The distribution of property upon dissolution. When an unincorporated association dissolves, the distribution of its remaining property depends on how the property was originally held. Courts have used varying methods to address this issue. Resulting trusts. In older cases, courts treated property as held on resulting trust for the contributors. This assumes that contributions were made for specific purposes, which fail upon dissolution. However, this approach is problematic because it implies invalid non-charitable purpose trusts. Contract holding theory. Modern courts favor the contract holding theory. Under this model, property held for members under the association's rules is distributed among the existing members upon dissolution. For example, in Rebuck's Constabulary, Widows and Orphans Fund Friendly Society, No. 2, 1979, property was divided equally among members when the association dissolved. Bona vacantia. In rare cases, property may pass to the Crown as bona vacantia if the association's rules and contributions cannot identify ownership. Carnac v. Edwards, 1896. However, this approach is rarely favoured in modern law. Conclusion. Unincorporated associations exemplify the challenges of balancing legal formality with practical governance. Through the development of doctrines like the contract holding theory, courts have provided workable solutions to issues of property holding and distribution. However, the intersection of trust law and unincorporated associations remains a dynamic and evolving area of equity. Thank you for joining me in this discussion. In our next episode, we'll delve into resulting trusts. Resulting trusts, their nature and application. Welcome to today's episode, where we explore the fascinating concept of resulting trusts. Resulting trusts are unique because they emerge from the circumstances of property transfer, often jumping back to the original owner or settler. We'll unpack their definition, the situations in which they arise, and the theoretical debates that surround them. By the end of this discussion, you'll have a deeper understanding of this crucial area of equity and trust law. What are resulting trusts? The term resulting comes from the Latin resulare, meaning to jump back, though nothing physically jumps back in a resulting trust. Instead, this concept signifies that property is held by a transferee on trust for the transferor when certain legal or factual circumstances exist. Resulting trusts address situations where the transferor's intention is unclear or the trust's purpose has failed. Broadly speaking, there are two categories of resulting trusts. Presumed resulting trusts, PRTs. These arise when the law presumes, in the absence of contrary evidence, that the transferor did not intend to gift the property to the transferee. Automatic resulting trusts, ARTs. These occur by operation of law when an express trust fails, regardless of intention. We'll delve into the distinctions between these categories and their implications shortly. When do resulting trusts arise? Resulting trusts arise in three main scenarios. Voluntary conveyances. When property is gratuitously transferred to another person, the law presumes that the recipient holds it on trust for the transferor, unless the evidence suggests otherwise. This is the essence of a presumed resulting trust. For example, in Dyer v. Dyer, 1788, the court held that contributions to the purchase price of property resulted in a trust for the contributor. Exceptions include presumption of advancement. Certain relationships, such as those between parent and child, assume the transfer is a gift. Statutory provisions, Section 63 of the Law of Property Act. 1925 modifies these presumptions in some land-related transfers. The purchase money resulting trusts. These arise when one person contributes to the purchase price of property held in another's name. Unless the presumption is rebutted, the contributing party retains an equitable interest proportional to their contribution. Cases like the Venture, 1908, demonstrate this principle. Failed trusts. When an express trust fails, due to vagueness, illegality, or lack of beneficiaries, an automatic resulting trust arises. The property reverts to the settlor, as seen in Maurice B. Bishop of Durham, 1804. Why do resulting trusts arise? The question of why resulting trusts arise sparks considerable debate. Scholars and judges offer competing theories. Retention theory. Advocates argue that resulting trusts reflect the transferor's retention of equitable interest. In Vandervelde v. IRC, 1966, Lord Wilberforce supported this view, suggesting that equitable interest is retained unless explicitly transferred. What absence of intention theory. Others like Lord Millett in Air Jamaica v. Charlton, 1999, argue that resulting trusts respond to a lack of intention to benefit the transferee. This perspective shifts focus from the transferor's retention to the transferee's absence of beneficial entitlement. Common intention theory. Lord Brown Wilkinson in Westdeutsch. Landesbank Bears Islington LBC, 1996, viewed resulting trusts as fulfilling the presumed intentions of the parties. This approach emphasizes shared expectations. Rebutting presumptions. Presumptions underlying resulting trusts are rebuttable. Evidence showing the transferor's intention to gift or loan property negates the trust. For example, in Folks v. Pascoe, 1875, the court found that a transfer to a surrogate grandchild was a gift based on contextual evidence. Quistclose trusts, a special case. Quistclose trusts occupy a unique position within resulting trusts. They arise when funds are transferred for a specific purpose. If the purpose fails, the funds revert to the transferor. As seen in Barclays Bank v. Quistclose Investments, 1970, these trusts ensure that the transferee holds funds on trust for the transferor unless the intended purpose is fulfilled. Conclusion. Resulting trusts demonstrate equity's adaptability in addressing ambiguous or failed transactions. Whether presumed or automatic, they ensure fairness by redirecting property to its rightful owner or resolving unintended outcomes. However, the debates surrounding their theoretical basis highlight the complexity and evolution of this area of law. Thank you for joining me in this exploration of resulting trusts. In our next episode, we'll examine constructive trusts and their unique role in addressing unconscionable conduct and unjust enrichment. Constructive trusts, their role and application. Welcome to today's episode, where we delve into constructive trusts, a fascinating area of trust law that deals with situations where equity imposes a trust to address fairness or prevent unjust outcomes. Unlike express trusts, which are deliberately created, constructive trusts arise by operation of law. Today we'll explore clear and disputed examples, examine their types, and analyze the reasoning behind their imposition. Introduction. Constructive trusts arise not from a settlor's intention, but from circumstances where equity deems it necessary to address wrongdoing, unjust enrichment, or other legal issues. They serve as a remedy, ensuring that property is held fairly in situations where strict legal ownership may lead to unjust outcomes. As we'll see, constructive trusts operate in diverse contexts, from fiduciary breaches to mistaken payments. Clear examples of constructive trusts. Certain situations provide well-established examples of constructive trusts. Is vendor-purchaser situations. When a contract to sell land is formed, equity regards the vendor as holding the title on trust for the purchaser. This principle, established in Lysart v. Edwards, 1876, reflects equity's maxim that equity treats as done that which ought to be done, perfecting imperfect gifts. In Re Rose, 1952, a trust was imposed when a donor completed all necessary steps to transfer shares. Even though formal registration was pending, equity recognized the recipient's beneficial interest despite the incomplete transfer. Fiduciary breaches. A fiduciary who profits from their position holds those gains on trust for the principal in FHR European Ventures LLP v. Cedar Capital Partners LLC, 2014. Secret commissions received by a fiduciary were held on constructive trust for the principal. Mistaken payments. In Chase Manhattan Bank v. Israel, British Bank, 1981, funds mistakenly paid were held on trust for the payer. Although the reasoning in this case has been criticized, it highlights equity's intervention to prevent unjust enrichment. Disputed examples of constructive trusts. Not all instances labeled as constructive trusts are universally accepted. Liability to account. Courts sometimes describe third parties involved in trust breaches as constructive trustees, even though they hold no property. In Dubai, Aluminium Co., Ltd v. Salam, 2003, Lord Millett questioned the appropriateness of this terminology, suggesting these individuals are merely liable to account in equity. Secret trusts. Secret trusts, where property is left for purposes communicated informally to trustees, have sparked debate over whether they should be classified as constructive or express trusts. Types of constructive trusts. Constructive trusts are categorized as either institutional or remedial. Institutional constructive trusts. These arise automatically based on established rules, independent of judicial discretion. For example, trusts in fiduciary breaches or vendor-purchaser situations fall into this category. Courts simply declare their existence. Remedial constructive trusts. These arise at a court's discretion to achieve fairness in specific cases. Although recognized in jurisdictions like the United States, English law has consistently rejected them, as seen in Polypec International v. Nadir, 1992, and Angoves PT Listed v. Bailey, 2016. Critics argue that remedial trusts undermine certainty and predictability in property law. The basis for constructive trusts. Understanding why constructive trusts arise involves analyzing equity's response to different situations. Wrongs. Constructive trusts often respond to wrongdoing, such as breaches of fiduciary duty. In Keach v. Sandford, 1726, a trustee's unauthorized profit was held on trust for the beneficiary, reinforcing the principle that fiduciaries must avoid conflicts of interest. Unjust enrichment. Equity intervenes to prevent recipients from being unjustly enriched. For instance, mistaken payments, as in Chase Manhattan Bank, may give rise to constructive trusts to ensure restitution. Other events. Constructive trusts can also arise in unique contexts, such as mutual wills or donatio mortis causa, where equity enforces fairness based on informal agreements or last-minute gifts. Criticisms and challenges. Constructive trusts have faced criticism for their reliance on open-ended concepts like unconscionability. Critics argue that such terms lead to unpredictability and arbitrary decisions. The distinction between institutional and remedial trusts, though theoretically clear, can blur in practice. Cases like Pennington v. Wayne, 2002, highlight equity's struggle to balance fairness with legal certainty. Conclusion. Constructive trusts illustrate equity's adaptability in addressing diverse legal and moral issues, whether responding to wrongdoing, unjust enrichment, or other circumstances. They ensure that property is held and used fairly. However, their theoretical foundations and practical applications continue to provoke debate, reflecting equity's dynamic role in modern law. Thank you for joining me in this discussion. In our next episode, we'll explore secret trusts and their intimate relationship with the principles of equity. Secret trusts, their nature and legal complexity. Welcome to today's discussion, where we delve into the intriguing world of secret trusts. These are a fascinating anomaly in trust law, operating outside the formal requirements typically imposed by legislation. We'll explore what secret trusts are, why they exist, the justifications for their recognition, and the complexities they introduce into equity and testamentary law. By the end of this episode, you'll gain a clearer understanding of their function and relevance. What are secret trusts? Secret trusts are testamentary trusts that deviate from the formalities required by the Wills Act 1837. There are two primary types. Fully secret trusts. These arise when a will appears to leave property to a legatee absolutely, but the legatee has secretly agreed to hold the property on trust for a third party. The existence of the trust is not mentioned in the will. Half-secret trusts. These occur when the will acknowledges that the legatee is to hold the property on trust but does not disclose the beneficiaries or purposes of the trust. For example, a will might state, £10,000 to John, on trust for purposes I have communicated to him. Secret trusts allow testators to circumvent the public nature of wills, avoiding scrutiny while providing flexibility to change arrangements without formally amending their wills. Justifications for secret trusts. Secret trusts raise significant legal questions because they bypass the statutory formalities of the Wills Act 1837. Two primary theories justify their recognition. The fraud theory. This theory asserts that secret trusts prevent fraud. If a legatee who agreed to act as a trustee later denies the arrangement, they would unjustly enrich themselves. Equity intervenes to enforce the trust, ensuring the testator's wishes are honoured. However, this rationale faces criticism for its circular reasoning and struggles to explain half-secret trusts, where fraud is less apparent. The day horse, outside the will. Theory, advocated in cases like Blackwell v. Blackwell, 1929. This theory suggests that secret trusts arise independently of the will. The obligation is created when the trustee accepts their role, rendering the Wills Act irrelevant. While this approach avoids the fraud rationale's limitations, it raises questions about the reliability of informal evidence and blurs the line between trusts and wills. Phase. Requirements for a valid secret trust. For a secret trust to be enforceable, certain conditions must be met. Communication. The testator must communicate the terms of the trust to the trustee. For fully secret trusts, this can occur at any time before the testator's death. In half-secret trusts, the communication must occur before or at the time of the will's execution, as emphasized in Re Keen, 1937. Acceptance. The trustee must accept their role, either explicitly or through acquiescence. Without acceptance, no trust arises, as seen in Re Boys, 1884. Certainty of terms. The trust's terms must be sufficiently clear. Ambiguity can render the trust invalid, leaving the property to pass under the terms of the will or via intestacy. Challenges and controversies. Secret trusts introduce several legal complexities. Timing of communication. Fully secret trusts allow flexibility, while half-secret trusts require stricter timing. This distinction is controversial, with critics questioning its logical basis. Contradictions in the will. If the will contradicts the alleged trust, courts prioritize the will's terms, as in Re Keen. Consistency is critical to maintaining the integrity of testamentary documents. Multiple trustees. When there are multiple trustees, only those informed of the trust are bound, unless the property is held as joint tenants and communication occurred before the will's execution. Stead, 1900. Predecease of parties. If the secret beneficiary predeceases the testator, the gift typically lapses. However, Re Gardner, No. 2, 1923, controversially held that the beneficiary's estate could inherit, treating the trust as inter vivos rather than testamentary. Witnessing by beneficiaries or trustees. Under Section 15 of the Wills Act, a beneficiary who witnesses the will cannot benefit from it. Courts have extended this principle to secret beneficiaries, but allowed exceptions, as in Re Young, 1951. Are secret trusts express or constructive? Secret trusts' classification remains debated. Some view them as express trusts created by the testator's declaration, while others consider them constructive, arising from the trustee's acceptance. The distinction has practical implications, particularly for trusts involving land, where written evidence is required under Section 53, 1b of the Law of Property Act, 1925. Constructive trusts are exempt from this requirement, potentially offering a broader scope for enforcement. Conclusion. Secret trusts highlight equity's ability to adapt and uphold fairness, even when statutory formalities are bypassed. However, they also challenge the principles underpinning testamentary law, raising questions about evidence reliability, fraud prevention, and the balance between statutory rules and equitable principles. Thank you for joining me in this exploration of secret trusts. In our next episode, we'll examine the appointing, retiring, and removing trustees. Appointment, retirement, and removal of trustees. Welcome to today's episode, where we focus on the critical roles of appointing, retiring, and removing trustees within the realm of trust law. Trustees are the backbone of any trust, ensuring its proper administration and adherence to its terms. But what happens when trustees can no longer serve, or when new trustees need to be added? Let's explore the legal frameworks and practical considerations that govern these processes. Introduction. Trustees are essential for carrying out a trust's terms, but circumstances often require changes in the trusteeship. A trustee may become incapacitated, unfit, or simply unwilling to continue serving. Alternatively, a trust may require additional trustees to enhance decision-making or to comply with legal requirements. The powers to appoint, retire, or remove trustees can come from the trust instrument itself, statutory provisions, or the court's inherent jurisdiction. Each of these mechanisms comes with specific rules and considerations. The appointment of trustees. Initial appointment. For inter vivos trusts, the initial trustees are usually named in the trust instrument. In the case of a self-declaration of trust, the settlor is often the first trustee. Testamentary trusts, created through a will, frequently name executors as the first trustees. However, issues arise when nominated trustees refuse the role or are deceased. In such cases, hours to appoint initial trustees may fall to others, such as surviving trustees or personal representatives. New appointments. There are three primary occasions for appointing new trustees. Death or incapacity. When a trustee dies or a trust company becomes insolvent, replacements are necessary. Retirement or removal. Trustees who retire or are removed must be replaced to maintain the trust's functionality. Expanding the trustee body. Adding trustees can improve trust management or comply with statutory requirements, such as having 2 trustees for land trusts to facilitate overreaching. Statutory powers, such as those under Section 36 of the Trustee Act, 1925, often govern these appointments. These provisions allow surviving or continuing trustees to appoint replacements or additional trustees. Retirement and removal of trustees. Retirement. Trustees have a right to retire, but their retirement is often contingent on appointing a replacement to avoid disrupting the trust. For example, Section 39 of the Trustee Act 1925 allows a trustee to retire if a deed is executed and a replacement trustee is appointed. This ensures the trust remains properly administered. Removal. A trustee may be removed if they are unfit, incapable, or otherwise unable to fulfill their duties. Removal can occur through statutory powers. Section 36, 1 of the Trustee Act, 1925 allows for the removal of a trustee under specific conditions, such as incapacity or prolonged absence. Court intervention. The court can remove a trustee under its inherent jurisdiction when their conduct threatens the trust's proper administration. The welfare of the beneficiaries is the court's primary consideration, as highlighted in Letterstedt v. Breurs, 1884. Powers under the trust instrument. Many trust instruments include provisions for appointing, retiring, or removing trustees. These powers are typically granted to the current trustees, the settlor, or other specified individuals. However, such provisions can become problematic if poorly drafted, or if the designated individuals are deceased or incapacitated. Statutory powers often serve as a fallback in these situations. Statutory provisions. Trustee Act, 1925. Sections 36 and 39 of the Trustee Act 1925 provide a general framework for replacing or discharging trustees. These provisions address scenarios such as appointing new trustees upon a trustee's death or incapacity, allowing a retiring trustee to appoint a replacement, removing trustees who are unfit or incapable of serving, trusts of land and appointment of trustees, Act 1996. Section 19 of this Act empowers beneficiaries of full age and sound mind who are absolutely entitled to the trust property to direct the retirement or appointment of trustees. This partially overturns the decision in Re Brockbank, 1948, which denied beneficiaries the ability to direct trustee changes. The court's role. When statutory or trust instrument powers are insufficient, the court can step in. Under Section 41 of the Trustee Act 1925, the court may appoint new trustees if it is expedient and inexpedient to do so without judicial intervention. Additionally, the court's inherent jurisdiction allows it to remove trustees when their actions jeopardize the trust's proper execution, prioritizing the beneficiary's welfare. Vesting trust property. A critical aspect of trustee changes is the transfer of trust property. When trustees are appointed, they must acquire legal title to the trust assets. Similarly, retiring or removed trustees must relinquish title. Section 40 of the Trustee Act, 1925, facilitates this process by allowing deeds of appointment or retirement to vest property in the new trustees. However, some assets, such as land or company shares, may require separate formalities. Conclusion. The appointment, retirement, and removal of trustees ensure the smooth functioning of trusts. Whether through statutory powers, trust instruments, or court intervention, these processes balance flexibility with the need for continuity and proper administration. By understanding these mechanisms, we gain insight into the dynamic interplay between trust law's legal frameworks and practical realities. Thank you for joining me. In our next episode, we'll explore express trust relationships. The express trust relationship, duties, powers, and beneficiaries. Welcome to today's episode, where we explore the intricacies of express trusts, a cornerstone of equity and trust law. Express trusts are intentionally created to manage property for specific beneficiaries or purposes. Today we'll examine the rights and duties within an express trust, delve into trustees' powers and responsibilities, and discuss the rights of beneficiaries, including their ability to enforce the trust and access information. Introduction. Express trusts are a sophisticated legal concept that generate both personal and proprietary rights. Personal rights are enforceable against specific individuals, like a trustee, while proprietary rights bind third parties who come into contact with trust property. This combination of rights makes express trusts versatile and protective, ensuring the settlor's intentions are upheld and beneficiaries' interests safeguarded. Rights and duties in an express trust. The trust relationship involves a delicate balance of duties owed by trustees and rights held by beneficiaries. Trustees have fiduciary responsibilities including keeping proper trust accounts, distributing property as per the trust's terms, investing trust funds prudently. Failure to fulfill these duties can result in personal liability for trustees. Beneficiaries, on the other hand, possess rights that can bind third parties if trust property is improperly transferred. These include enforcement rights. Beneficiaries can hold trustees accountable for breaches of trust. Rights against strangers. Third parties who receive trust property in breach of trust may be required to return it unless they are bona fide purchasers for value without notice. Trustees' powers and duties. Trustees' powers are classified as fiduciary or personal. Fiduciary powers, such as investing trust property, must always be exercised in the beneficiary's best interests. Personal powers, by contrast, allow holders to act for their own benefit. Duties. Duty of care. Trustees must act with the skill and care of a prudent person. The Trustee Act 2000 codifies this duty, requiring trustees to consider professional expertise and the specific needs of the trust. Duty to act even-handedly. Trustees must balance the interests of income and capital beneficiaries fairly. Duty to avoid conflicts of interest. Fiduciaries must not use their position for personal gain. Dispositive and administrative powers. Dispositive powers concern the distribution of trust property, such as appointing beneficiaries or advancing funds. Administrative powers include managing investments, insuring property, and delegating tasks to agents. These powers are crucial for the efficient administration of the trust. Beneficiaries' rights and powers. Beneficiaries hold significant rights that allow them to enforce the trust and ensure its proper administration. These include right to be informed. Beneficiaries must be informed of their interests under the trust. Access to information. Beneficiaries are entitled to trust accounts and documents, but not necessarily to records explaining trustees' discretionary decisions. Re Londonderry Settlement, 1965. Right to collapse the trust. Under the principle in Saunders v. Bautier, 1841, adult beneficiaries with full mental capacity and an absolute interest in terminate the trust and demand the transfer of property. Investment and delegation. Trustees' investment powers are governed by the Trustee Act 2000, which grants broad discretion but imposes strict duties. Prudent investment. Trustees must ensure investments preserve capital value and generate reasonable returns. Diversification. Investments should be diversified to manage risk. Ethical considerations. While trustees must prioritize financial returns, ethical investments may be permissible if they do not compromise beneficiaries' interests. Cowan v. Scargill, 1985. Delegation is another key aspect of trustee powers. Trustees can delegate administrative functions but remain accountable for the agent's actions. Statutory provisions, such as Section 25 of the Trustee Act 1925, allow temporary delegation under strict conditions. Enforcement and accountability. Beneficiaries are the ultimate enforcers of a trust. They can sue trustees for breaches of trust, hold third parties liable for knowingly assisting or receiving trust property in breach of trust, enforce equitable remedies, such as following and tracing misappropriated property. These enforcement mechanisms ensure trustees adhere to their duties and safeguard the trust's integrity. Conclusion. The express trust relationship is a dynamic interplay of rights, duties, and powers. By understanding these elements, we appreciate how equity ensures fairness and protects the interests of all parties involved. Whether it's enforcing fiduciary duties or balancing beneficiaries' rights, express trusts remain a cornerstone of legal innovation. Thank you for joining me. In our next episode, we'll explore breach of trust. Breach of trust, trustees, and third parties. Welcome to today's episode, where we examine breaches of trust, an essential topic in equity and trust law. Trusts are built on the foundation of fiduciary responsibility, but when trustees fail in their duties or third parties interfere, serious consequences can arise. In this episode, we'll explore trustee liability, remedies available to beneficiaries, and the responsibilities of third parties implicated in breaches of trust. Introduction. A breach of trust occurs when a trustee violates the terms of the trust or general legal principles governing trusteeship. This might involve failing to distribute income or capital to beneficiaries, making unauthorized investments, or improperly transferring trust property. The liability for such breaches is primarily personal, meaning trustees may be required to restore trust losses out of their own pockets. However, third parties can also be held accountable if they knowingly assist in or benefit from a breach. Trustee, liability for breach of trust. Personal and proprietary rights. Beneficiaries can assert personal and proprietary rights against trustees who breach the trust. Personal liability requires trustees to pay compensation for losses caused by their breach. Proprietary claims allow beneficiaries to recover specific trust property or its traceable proceeds from the trustee or third parties. Falsifying and surcharging trust accounts. One primary way beneficiaries enforce accountability is through trust accounts. Falsifying the account. If trustees make unauthorized payments, beneficiaries can ask the court to falsify the account by declaring the transaction invalid. Trustees must either reverse the transaction or compensate the trust for any resulting loss. Surcharging the account. When trustees fail to take proper care, such as by neglecting to invest trust funds or insure trust property, beneficiaries can request the court to surcharge the account. This requires trustees to make up for the trust's diminished value. 2. Strict liability and defenses. In most cases, trustee liability for breach of trust is strict. Trustees are responsible regardless of their intent, negligence, or honesty. However, certain defenses may apply. Beneficiary consent. A fully informed and competent beneficiary's consent can excuse a breach. Exemption clauses. Trust instruments may include clauses limiting trustee liability, though these cannot shield trustees from acts of dishonesty or recklessness. Armitage v. Nurse, 1997. Relief under Section 61 of the Trustee Act, 1925. Courts may relieve trustees of liability if they acted honestly, reasonably, and fairly. Liability of third parties. Trustees, dishonest tort. A person who assumes control of trust property without being formally appointed as a trustee is deemed a trustee, dishonest tort. Such individuals are held to the same standards as properly appointed trustees and are liable for any breaches they commit. Dishonest assistance. Third parties who assist in a breach of trust can be personally liable if their actions are dishonest. The dishonesty test combines subjective knowledge with an objective standard of morality, as clarified in Royal Brunei Airlines v. Tan, 1995. Knowing receipt. Third parties who receive trust property in breach of trust may also be held liable. To succeed in a claim of knowing receipt, beneficiaries must prove the recipient knew the property was transferred in breach and dealt with it for personal benefit. Liability here has both proprietary and personal dimensions. Remedies and equitable compensation. Hold. Remedies for breaches of trust aim to restore the trust to the position it would have been in if the breach had not occurred. This may involve reversing unauthorized transactions, returning misappropriated property, or providing monetary compensation. The concept of equitable compensation ensures beneficiaries are made whole, even in cases where tracing specific property is not possible. Conclusion. Breaches of trust highlight the critical responsibilities of trustees and the potential liabilities faced by third parties. By enforcing strict accountability, equity ensures trust relationships are upheld and beneficiaries' rights are protected. However, evolving principles such as the tests for dishonesty and causation continue to shape this dynamic area of law. Thank you for joining me. In our next episode, we'll explore fiduciary duties and their role in equitable remedies. Breach of fiduciary duty, duties and remedies. Welcome to today's episode, where we delve into fiduciary duties and the implications of their breach. Fiduciary duties lie at the heart of trust law and other areas of equity, safeguarding the interests of principals against potential misuse by fiduciaries. In this discussion, we'll explore what fiduciary duties entail, key rules like the no conflict and no profit principles, and remedies available when these duties are breached. Introduction to fiduciary relationships. A fiduciary is an individual entrusted to act on behalf of another in a relationship of trust and confidence. Trustees are the paradigmatic fiduciaries, but the concept extends to company directors, agents, solicitors, and others who exercise discretion for their principals. The essence of a fiduciary relationship is the fiduciary's duty to prioritize the principal's interests, avoiding conflicts and improper benefits. Distinguishing breach of fiduciary duty from breach of trust. A breach of trust occurs when trustees violate the terms of the trust or general trustee duties, such as unauthorized investments. Breaches of fiduciary duty, however, involve actions where fiduciaries place their interests above those of their principals or misuse their positions for personal gain. For example, investing trust funds in a company where the trustee has personal interests constitutes a breach of fiduciary duty under the no conflict rule. Key rules governing fiduciary duties. The no conflict rule. Fiduciaries must avoid situations where their personal interests conflict with their duties. This rule applies even if the conflict does not result in actual harm to the principal. For instance, in Boardman v. Phipps, 1966, a solicitor acting for trustees profited from purchasing shares. Although the profits benefited the trust, the court held the solicitor accountable under the no conflict rule. The no profit rule. Fiduciaries are prohibited from retaining unauthorized profits derived from their positions. For example, in Williams v. Barton in 1927, a trustee earned a commission by introducing trust business to a brokerage. The court required the trustee to surrender the commission, reinforcing that fiduciaries cannot exploit their roles for financial gain. The self-dealing rule. When fiduciaries transact with their principals, such as buying trust property, the self-dealing rule applies. Unless beneficiaries give fully informed consent, such transactions are voidable, regardless of fairness. Exceptions are rare and must be justified by unique circumstances, as seen in Holder v. Holder, 1968. The fair dealing rule. This rule addresses situations where fiduciaries purchase beneficiaries' interests in the trust. To avoid liability, fiduciaries must demonstrate they acted transparently, disclosed all relevant information, and offered fair terms. In Re. Thompson's settlement, 1986, the burden of proving fairness lay squarely on the fiduciary. Remedies for breach of fiduciary duty. Rescission and reversal. Courts may rescind transactions resulting from breaches of fiduciary duty, restoring the parties to their original positions. If rescission is impossible, equitable compensation or disgorgement of profits may apply. Amount of profits. The fiduciaries must account for unauthorized gains derived from their breaches. In FHR, European Ventures LLP v. Cedar Capital Partners LLC, 2014, the Supreme Court held that profits made by a fiduciary from a bribe were held on constructive trust for the principal, allowing beneficiaries to trace the funds. Equitable compensation. If breaches result in financial loss, courts award equitable compensation to restore the principal's position. Unlike common law damages, equitable compensation focuses on actual losses caused by the breach, considering hindsight and fairness. Nocton v. Lord Ashburton, 1914. Trustee exemption clauses. Trust instruments often include exemption clauses to limit trustees' liability. However, these clauses cannot shield trustees from liability for dishonesty or recklessness, as held in Armitage v. Nurse, 1997. The scope of such clauses in fiduciary breaches remains uncertain, as illustrated in Barnsley v. Noble, 2016, where trustees relied on an exemption clause to escape liability for self-dealing. Conclusion. Fiduciary duties underscore the importance of loyalty and integrity in relationships of trust. Breaches of these duties trigger strict accountability, ensuring fiduciaries act in their principal's best interests. As we navigate evolving fiduciary relationships, courts continue to refine these principles, balancing fairness with robust protections for principals. Thank you for joining me. In our next episode, we'll explore the doctrine of tracing. Tracing in trusts, a deep dive into recovery processes. Welcome to today's episode, where we focus on tracing, a vital process within trust law. Tracing allows beneficiaries to follow or track the movement of trust property that has been misappropriated. This concept underpins both proprietary and personal claims, ensuring that trust property or its value can be recovered, even when it has passed through multiple hands or been converted into other forms. In this discussion, we'll explore the principles of tracing, examine key rules, and address some of the controversies surrounding this fascinating area of law. Introduction to tracing. Tracing is a process used to identify the proceeds of trust property that have been transferred or exchanged. It enables beneficiaries to claim the value of their property in its new form or from its current holder. This process becomes essential when property is no longer in its original form, having been sold, exchanged, or mixed with other assets. The starting point in tracing is distinguishing it from similar processes. Following, tracking property in its original form as it moves from one person to another. Tracing. Identifying property that has been exchanged or converted into another form. Claiming. Asserting rights over the property that has been followed or traced. For example, if trust money is used to buy a car, tracing allows beneficiaries to claim the car as the proceeds of the trust property. Common law and equitable tracing. Tracing can occur under both common law and equity, but the two systems differ significantly. Common law tracing. Under common law, tracing applies to property where the claimant retains legal title. However, common law tracing cannot follow property through mixtures or changes in form. The foundational case of Taylor v. Plumer, 1815, illustrates these limitations. This rigidity often leads claimants to rely on equitable tracing, which offers greater flexibility. Equitable tracing. Equitable tracing is available to beneficiaries of a trust and other parties in fiduciary relationships. Unlike common law, equity allows tracing through mixtures, provided a fiduciary relationship exists. The case of Diplock in 1948 confirmed that fiduciary relationships enable claimants to use equitable tracing rules, even in complex scenarios. Rules of tracing. Tracing rules vary depending on the circumstances and parties involved. Tracing through mixtures. When trust property is mixed with other funds, equity uses specific rules to determine ownership. Maharat's estate, 1880, presumes that a wrongdoer spends their own money first, leaving trust money intact. Re-Otitwe, 1903, allows beneficiaries to claim specific assets purchased with trust money if the remaining funds are dissipated. Lowest intermediate balance rule limits recovery to the lowest balance in a mixed account, as established in James Roscoe, Bolton, Littered, Barr, Winder, 1915. Backwards tracing. Backwards tracing permits claimants to trace trust money used to repay loans or debts incurred before the property was purchased. While traditionally disallowed in English law, Bishopsgate Investment Management, Littered v. Homan, 1995. The Privy Council's decision in Federal Republic of Brazil, B. Durant International Court, 2015, recognized backwards tracing in cases with a close causal link between the debt and trust property, totality, proprietary and personal claims. Tracing supports two types of claims. Proprietary claims. Beneficiaries can assert ownership of traceable proceeds, such as claiming a car purchased with trust money. If the property's value has increased, this claim ensures beneficiaries benefit from the rise in value. Personal claims. Personal claims arise against wrongdoers or third parties who knowingly deal with trust property. For instance, someone who knowingly receives misappropriated funds can be held liable under a personal claim. Subrogation. Subrogation is another remedy available through tracing. It occurs when trust money is used to discharge a secured debt, such as a mortgage. Beneficiaries are subrogated to the rights of the creditor, gaining the right to recover the property. The case of Boscawen v. Bajwa, 1995, exemplifies this principle, where trust money was used to pay off a mortgage, enabling beneficiaries to claim the security. Challenges and controversies. Tracing is not without its challenges. Disputes often arise over the application of rules like the lowest intermediate balance or the validity of backwards tracing. Additionally, questions about fairness and competing claims can complicate recovery efforts. These challenges highlight the delicate balance courts must strike between equitable principles and practical realities. Conclusion. Tracing is an indispensable tool in equity, ensuring that trust property can be recovered and misappropriated assets restored. By combining rigorous rules with flexible applications, it protects beneficiaries' interests while addressing complex financial transactions. However, as financial practices evolve, so too must tracing rules, ensuring they remain fit for purpose in a modern legal landscape. Thank you for listening to this podcast. Have a look around Dr. Yannis' channel for more key SQE FLK podcasts.